If you are considering setting up a trust, there are going to be three main parties named in that trust document. There's going to be grantors, there's going to be trustees, and there's going to be beneficiaries. And when you set up a trust, it's super important to understand how each role interacts within that trust document, as well as common mistakes people make when assigning trustees or beneficiaries that you need to be aware of. And we're going to be covering all that in this video today. Hello everyone, I am Michael Ruger. I am the managing partner of Greenbush Financial Group. With more and more revocable trusts and irrevocable trusts being created for tax planning, long-term care planning, and estate planning, we thought it would be helpful to define the three main roles associated with a trust document. Now, the grantor being number one, so grantor is also sometimes called the settler of the trust. This is the person that actually gives the assets or gifts the assets to the trust. In addition to the grantor being the one that actually funds the trust, whether it's with real estate or stocks or cash or other assets, the grantor is the one that sets up the trust documents that ultimately names who are the trustees, who are the beneficiaries, and how and when assets will be distributed from the trust. Role number two in the trust is the actual trustee, which is the individual or institution that's actually responsible for managing the trust assets in accordance to the power granted to them within the trust document. The trustee or trustees have numerous responsibilities. Number one being maintaining and safeguarding trust assets. Number two, following the instructions set forth in the trust document. They ultimately distribute the funds to the beneficiaries, and they maintain records, filing taxes, and act as a fiduciary on behalf of the trust assets. When setting up a revocable trust or a living trust, it's common that the grantor and the trustee are the same individuals, versus when you're setting up an irrevocable trust, it's actually more common that the grantor and the trustee or trustees are different people. Now, what happens if you set up an irrevocable trust, but you don't have someone close enough to you that you trust to serve as a trustee to your assets? So in those cases, sometimes an individual will hire what's called a corporate trustee, like a trust department at a bank or at a law firm, and they serve as the corporate trustee on your behalf. The third role are the beneficiaries, which are the individuals that either receive a benefit now or a benefit in the future from those trust assets. Depending on the type of trust you're setting up, the same individual might be serving more than one role within that trust relationship, whether they're both the grantor and the trustee, or maybe they're both a trustee and a beneficiary of the trust. When someone is looking to set up a revocable trust or a living trust, usually the primary objective of doing that is so their assets avoid probate, not necessarily to relinquish control of those assets. So it's not common in the revocable trust where the grantor and the trustees are the same individuals and the beneficiaries are someone who's different. So a common example would be, that a married couple, they set up a trust so all their assets avoid probate. Their kids are named as beneficiary of the trust, so that allows them to maintain control of the assets, manage the assets, and then after the second spouse has passed away, that's when those assets are distributed to their kids but avoid the probate process. When someone sets up an irrevocable trust, they're usually intentionally trying to relinquish control of those assets, and the two primary reasons are they're trying to protect those assets from a future long-term care event, or they're trying to shrink the size of their estate to avoid estate taxes. In those instances, because they're intentionally trying to create an arm's length to their assets, usually the grantor and the trustee are not the same person, because if you still have control, it can be argued, did you really give those assets away, or do you still have too much control and it's really still considered your asset? Here's an example. Let's say Sarah is 80 years old and she's trying to protect her assets from a future long-term care event in the Medicaid spend down process. And she wants to make sure her house and her brokerage accounts go to her son, Ian. In that case, she might set up an irrevocable trust. She is the grantor giving her assets to the irrevocable trust, but she may name her son Ian as both the trustee of the trust, which is maintaining the trust assets, but Ian may also be 100% beneficiary of the trust as well. And then there are definitely irrevocable trust arrangements where the grantor, the trustee, and the beneficiaries are all different people. Where a parent might say, hey, we're establishing this irrevocable trust. Our kids are going to be the beneficiaries, but in the interim, we don't want the kids maintaining the trust. So we're going to name a third-party person or a corporate trustee to manage the assets, which will ultimately be distributed to the kids. We see a number of common mistakes that individuals make when designating these various roles within the trust. mainly around the role of a trustee. So if you're naming a trustee someone other than yourself, you truly have to trust them because they're designated a lot of power. They can open accounts for the trust, they maintain assets for the trust, they distribute assets for the trust, so they really have to have the skills and the time capacity needed to fulfill that role. When the grantor of the trust creates their trust document, they actually designate what powers the trustee does and does not have. And one of the ones we say to be the most careful with is the power to gift. So you can give your trustee the power to gift assets from the trust while you're still alive. But where you have to be very careful is where the trustee is both the trustee and the beneficiary. So essentially they could make gifts to themselves if need be. The second major mistake we see people make is not reviewing their trust document with their estate attorney after there's been a major event in the family, whether it's the death of a family member, a birth of a family member, or maybe there's been a divorce within the family. Another major mistake is not updating your trust document after you've changed your state of domicile. So if you move from New York to Florida, the estate tax rules may be different, so it might require you to make some adjustments to the language in your trust document. And the final mistake is not updating the trust document when there's big changes in the tax laws or tax legislation. We've had individuals that had trust for 20 years and never made any update to their trust document, but they did their trust back when the federal estate tax exemption was $1 million, but now it's 13 million. So before the game might have been, hey, do an irrevocable trust and get it out of your estate. But now that the estate tax exemption is so large, it might change that strategy, say, no, you want it to be in your estate so your beneficiaries get the step up in cost basis to avoid the big tax liability. When it comes to trust, there are 5 main planning tips. Number 1 is review your trust documents regularly and confirm who is named in each role. Number 2, confirm all powers you have provided to the trustee. Number 3, name a backup or successor trustee in case your primary trustee can't serve. Number 4, pick a trustee who's reliable, impartial, and financial competent. And number 5, make sure your beneficiaries are clearly defined and up to date. I hope this information was helpful. If you have any questions, please feel free to reach out to me at greenbushfinancial.com. Thank you.